All right, we will momentarily put aside the Boyette case and get back to that later on. Let's proceed with the next case, which is Kristopher Sanders versus the state of Florida. Mr. Bulletin, you may proceed, sir.
May it please the court, I'm Steve Bulletin from the Public Defender's Office in Bartow. I represent the appellant Chris Sanders. I'm going to try to argue 6 issues, the first 6 issues in the brief today, and I know that there's no way that's going to happen, so that anything I don't get to, I'll rely on the brief. I'll start with the issue that goes to the conviction, which is the restriction of the cross-examination of the key state witness, George Nasheff. Nasheff was a crucial witness in this case in the sense that his testimony was used by the state to rebut appellant's version of what occurred that the state itself presented through his taped statement to Detective Bloom. They called Nasheff for the purpose of, the witness stated that he was at Joey Duckett's house, Joey Duckett being the mastermind, the organizer of the crime. He claimed that he received a phone call from appellant telling him to come over to the LaSalle apartments, which he then did, and he was told that Hank was picking up Chris Sanders, and that George Nasheff was to follow him out to Belcher's Mine and pick him up. This testimony was inconsistent with 3 different versions that Nasheff had given before. Nasheff had previously told Detective Bloom that he was not involved in any way, that he had picked appellant up, but he had left out the part about going to the LaSalle apartments. And then on the 3rd occasion, in deposition under oath, he stated that Joey Duckett had told him, had sent him out there to pick up appellant. He explained on direct examination, the state brought out from him that the reason for his inconsistent statement and his lies was fear. He was afraid of Joey Duckett. He was afraid, and that was gone into in some detail. On cross, or actually recross, I need to go back to one additional point in Chris Sanders' statement. He stated that numerous people were involved in the planning of this crime. Joey Duckett, who had ordered it done, Wayne Sargent, Ole Anderson, the aforementioned George Nasheff, and that Nasheff was the coke man, that the whole reason that this had been ordered by Joey Duckett was to take Hank out so that George and his brother could move in.
Who testified about that?
That came in through the defendant's tape statement to Detective Bloom. Okay, Nasheff, on the other hand, basically portrayed himself as an outsider that was in over his head. He didn't know what was going on. He wasn't part of these people. He, when he was out there and he saw Chris Sanders and there was blood, and he never would have come out there if he'd have known what was going to happen. And he portrayed himself to the jury as a scared, basically innocent bystander. On recross, the defense asked him, you say you're afraid of this group of people. Weren't you a part of this group of people? George Nasheff denied that, and then at that point the defense asked, well, haven't you been running drugs for them? At that point the state objected and a proffer was held outside the hearing of the jury. It was brought out at that point. Nasheff put out, he only at one time, he says, did he run drugs for Joey Duckett and his gang, which would be Joey Duckett and appellant, according to Nasheff. The other 3 or 4 runs had to do with Ole Anderson. That would be, according to Nasheff, another group, Ole and Wayne. The point here is that all of these people are involved in the planning of this crime together. Ole and Wayne and Chris Sanders and Joey Duckett. Now, Nasheff's testimony was critical to the state in defeating the defense, which came in through the tape statement to Detective Bloom, which was that even though this crime was supposed to occur, it wasn't supposed to occur for another 2 weeks. Chris Sanders and Hank had gone to Tampa. Hank had bought some crack cocaine. They returned back to Pasco County. Hank was acting crazy. Hank was smoking up all the crack. He was acting reckless, parking off the side of the road. An argument ensued. Hank was getting paranoid. He reached for a cattle prod, which he had in the truck, which was later found there. Appellant overreacted, pulled his gun and shot Hank. And he testified, well, he didn't testify. He told Detective Bloom in the tape statement that this was, as he put it, an accident. This was an overreaction. It was just stupid. It wasn't a robbery. It wasn't planned. The Joey Duckett planned crime was not supposed to occur for another 2 weeks. Now, the state presented, this tape statement was presented by the state, but the state's approach, which is entirely legitimate, is in this situation to say, okay, we're going to present his statement because we want to use it to show you, yeah, he's admitting doing the crime, and there's certain aspects of this statement that we like and we want you to believe. But there's other aspects of the statement that we don't like and we don't want you to believe, and we're going to use other evidence to try to refute that. And the other evidence that they used to refute the lack of premeditation was George Nashef. George Nashef was critical both to premeditation and to the only aggravating circumstance that was argued or instructed on or found in this case, and that was CCP. The trial judge in his order specifically relied on the testimony of George Nashef to defeat the defense that this was an unpremeditated crime and that this was not a cold, calculated, and premeditated crime in the penalty phase. The Crawford cross-examination was classic cross. It was relevant for two reasons. It was germane to matters that were opened up on direct by the prosecution, specifically Nashef's claim of fear of Joey Duckett, fear of these people, claim not to be involved with these people, claim that, in effect to be an innocent bystander, that he didn't know what was going on, that he wouldn't have had anything to do with it if he had known what was going on. This is not, it's important to note here that this is not some kind of collateral or tangential drug activity. We're going to show this witness is a bad guy because he uses drugs or because he deals drugs. That may be relevant in some contexts, it may not in some other contexts, but that's not what's going on here. What's going on here is that these are all people who, according to the state's own version of the evidence, are involved in the planning stages of this crime. And it's critical for the jury to know what George Nashef's role was, what George Nashef's relationship to these people was, what might have been George Nashef's motivation for lying to Detective Bloom on two prior occasions, and for lying under oath in a deposition. The right to cross-examination, when it's relevant cross, is absolute. It's a right, not a privilege, and its limitation or restriction when it's applied to a key state witness is often going to be reversible error unless it can be shown to be harmless. It's clearly not harmless under the circumstances of this case. Okay, I'm going to move on to the penalty phase. Talk first about the issue, I guess legally one of the simpler issues in the case, which is the violation of Florida Rule of Criminal Procedure 3300B and the case law established by this court in O'Connell versus State, in Hernandez versus State, in Willacy versus State. That is that there was a death scruple juror during voir dire, Miss Claire Payeur. The judge basically said, okay, I'm going to ask a few preliminary questions, all these jurors, then I'm going to let counsel, prosecution, and the defense ask some questions as well. This is specifically guaranteed. Rule 3300B says the judge may ask some questions, but in two sentences out of this four-sentence rule, it emphasizes that the right and the duty of counsel to have a reasonable voir dire examination of each juror shall be preserved, twice in that rule. What happens here is the judge, after he's through with Ms. Payeur, says, okay, I'll turn it over to you, prosecutor, which is the way the rule says it should go. Prosecutor says, no, wait a minute. Prematurely, the prosecutor challenges two jurors for cause before any attorney, any counsel has had any opportunity to examine or rehabilitate them. The defense says, wait a second here, I have a right to question Ms. Payeur, I have a right to try to rehabilitate her. The state makes the exact same argument that the judge had erroneously made in O'Connell, says, well, he can't rehabilitate her because she's already said the magic words, she's gone, so I challenge her for cause. The judge granted the challenge for cause after the judge asked a few more questions, but again, this is the judge, not counsel, asks a few more questions and grants the state challenge for cause. Defense renews its objection. I have a constitutional right to examine, to attempt to rehabilitate this juror.
Do you concede that there could be any instances in which a juror or prospective juror could make statements that were so extensive or perhaps so extreme on the issue that would permit the court to go ahead and excuse that juror without inquiry by counsel?
Well, let me put
is there potential for any cases like that?
I think on other kinds of issues, yes, and that might be look at the Green case and the Fleckinger case out of the 4th DCA. On death qualification, I'd be loath to concede such a thing. I would point out here on Ms. Payeur's answers, I don't want to say that they reached that level even if such a level theoretically could exist. Now, her answers clearly, if nothing other than what she said got said, then her answers clearly would have supported the judge granting the challenge for cause, but that was exactly the case in Willacy and O'Connell as well. Her answers were no more unequivocal than the jurors' answers in O'Connell, and if anything, a little less.
You just said a moment ago, if it were some other issue, perhaps, yes, the statements would serve as
I can
disqualification
conceive that if
here.
it were another issue, I mean, if it were, I don't think the court is likely to adopt a rule that's going to say that on, in any kind of case, death case, civil case, then even if it's on some kind of point, if the juror says something, the case I'm thinking of now is Fleckinger again, where the juror said, I'm not evolved enough to sit in judgment of anybody in any case. Maybe that could fall into that circumstance. So I'm not going to go so far as to say that there could never be a case, because I don't feel like I have to go that far in this case. This case was almost identical to O'Connell and Willacy. If anything, the juror was less. Look at the jurors' answers in Willacy. They were, if anything, more unequivocal than here. And yet the court said, well, the judge was right in granting the challenge for cause, but committed a reversible error, at least as to the penalty phase, in not allowing the right to any examination whatsoever of this juror on voir dire. There's a slippery slope problem here as well. O'Connell, Hernandez, and Willacy have all been on the books. O'Connell for years. That was my case. I think it was 1985. Rule 3300B is very, very clear and unequivocal. Says it twice in 4 sentences in the rule. The judge should have been aware of it. The prosecutor certainly should have been aware of it. I think that to make any kind of harmless error argument here, you got to realize the prosecutor caused this problem. The judge was ready to say, okay, counsel, go ahead, it's your turn. Prosecutor says, wait a minute, I challenge him for cause. It was premature. The defense says, hey, I want to examine the witness. If the prosecutor was so sure that it couldn't have mattered, that no effective voir dire could have been done, prosecutor should have sat down and say, fine, have at it. But he didn't. And I think that the state should bear the consequences of its actions when this case law is so clear, is on the books. The law needs to be followed. There is no reasonable basis to deny Chris Sanders the relief that was granted to Barry O'Connell and Mr. Hernandez and Mr. Willacy.
The court did ask additional questions, is that correct, of these particular?
Well, then there you're just getting into the question of the order of which the court's questions were asked. Were they asked before the objection or after the objection? There's no meaningful difference between the cases to distinguish it on that.
And this would work both ways. That is that if this was a witness also that said, no, once I've heard that it was the murder of a police officer, for instance, the death penalty is the only thing that I could vote for, you would agree that the state would be entitled to ask questions to attempt to cure that kind of a response.
Yes, I would agree that it would work for the state. It would also work for counsel in a civil case, I believe. Actually, I'm not sure if the civil rule is identical, but I think so. I'm going to back off on that. Certainly, it would work for the state. The difference might be the fact that it would be something. The only way the state could appeal would be in the situation of a cross appeal, and since that's not an issue that's likely to recur, whether they would cross appeal it, I don't know. But certainly, if I were the trial judge, I would read O'Connell as saying, sure, the prosecutor can rehabilitate.
And is it clear here that it was preserved on the record that counsel consistently asked for the right to
twice and urged that the constitutional rights of his client were being violated? It's as preserved as it can be. I want to move on now to the issue regarding Dr. Sidney Marin, the switching sides issue here. The defense filed a motion for the appointment of a confidential expert to assist the defense in the penalty phase and in the preparation of the defense and for mitigating circumstances under Rule 3216A. The trial court granted the motion, and the defense contacted Dr. Sidney Marin and requested that he serve as the defense's confidential expert. It's not exactly clear whether Dr. Marin expressly or whether he tacitly agreed to do this, but it's very clear that he did not turn down the appointment. Dr. Marin testified that at the time that the defense sent appellant's voluminous medical and psychiatric records to him, that there may have been some communication, some conversation with defense counsel Swisher's office at that time. There was an ongoing period of 6 or 7 months in this case where appellant and defense counsel reasonably believed that Dr. Marin was serving as the defense's confidential expert under Rule 3216. As I stated previously, all of appellant's medical records and psychiatric records, which were extensive because he had been, throughout his teenage years, he had been diagnosed on several occasions with severe major depression, with dysthymic disorder. He had been hospitalized or institutionalized on at least 6 occasions. He had been receiving psychotropic medication. He had a history of self-mutilation. He had an extensive psychiatric background, and these medical records and psychiatric
Had
records.
any of those records or that information been disclosed to the state in other forms and otherwise? In other words, was that all? Did that all remain confidential at the time that he had those records in his office, or was that information disclosed to the state?
Well, I'm not sure I can tell that from the record. I mean, the state was aware of, I guess that which was public record. I don't, I'm not aware that anything was turned over to the state on discovery as far as his medical records.
I mean, your point here is that this was private, confidential information that this expert, who later testified for the state, otherwise would not have had access to. So if of course, the state had all of those records,
Well,
that would not be a valid.
okay, I certainly don't see anything in the record that would indicate that the state had all of those records. And whether they had some of those records or not, I don't know. But my point is not solely that if this had not been turned over to Marin, that the state would not have had access to. My point is additionally that Dr. Marin himself, once he was expressly or tacitly retained as the defense's confidential expert, had no right to participate in this case on the other side at all, either as a witness or in terms of consultation with the prosecution or discussion of strategy or possibly advising them how best to cross-examine the expert that the defense eventually did retain, Dr. Mahar. That what occurred here should have resulted in his non-participation in the case, not in his resurfacing as a state witness or as a psychiatric aid to the state.
Let me ask you this. It's a follow-up to Justice Ansted's question. It's asserted in the briefs on the matter that there were private communications between counsel and the defendant that were included in the information that was sent to Dr. Marin. Was that information that was sent to Dr. Marin made part of the record in this proceeding?
I don't think there's anything that's specific that says that, this is something that was communicated by the client to the attorney that was sent to Dr. Marin. I'm also not sure that that's what I said in the brief. I think what I said in the brief was that confidential records were sent. In addition, there were some indications that defense counsel told Dr. Marin, look, I want you to examine this videotape of his statement to Detective Bloom. I want you to look into the possibility of the voluntariness or involuntariness of the statement. He says that he just wanted to get out of there. He was telling him anything he wanted to hear. There are indications that he was huffing gasoline. There are some pictures you could look at that would tend to support the fact that he may have been impaired. I can't separate out. I don't actually have the medical records, and I can't separate out what was said by Sanders to Mr. Swisher and then sent to Marin, as opposed to just what Swisher told Marin.
My point is this record does not contain the specific communication with the records attached that the public defender sent to Dr. Marin, does it?
No, it does not. And for Mr. Swisher is a private attorney, not a public defender.
All right. So that those are not, we just have to go on basically what the comments were by counsel in the record in the objection.
And by what the comments were by Dr. Marin in responding, when he sent his letter of apology. I don't think there's really no dispute that confidential records were sent. That is, defense counsel asserts that, and nobody disputes that it's true. The only argument that was made by the state is, well, Marin never read them.
There was an order entered appointing Dr. Marin as a confidential expert, is that correct?
No, there's an order entered. The motion was, apparently this is the way the procedure is done in Pasco County, the motion was to appoint a confidential expert. Nobody was identified by name. There was an order granting that. The defense then contacted Dr. Marin, who appears to have agreed to do so. At that point, a further order was obtained authorizing Dr. Marin to see Chris Sanders in the Pasco County Jail.
That order, was that provided to the state?
I don't believe so. I don't see why it would have been.
It'd be part of the record, though.
Yeah.
All the record indicates through letters by Swisher to Marin that such an order exists. I don't believe the actual order is in the record. The order appointing an expert is.
You mean an order would be entered and not furnished to both sides?
I believe, I'm not sure of the procedure here, but I think where you're appointing a confidential expert, I'm not sure you would furnish that to both sides, would you? I could be wrong.
The state then was never aware that Dr. Marin had been contacted by the defense.
That's a little bit tricky. I mean, that, here what I'm arguing has to do with representations made by all sides at the hearing plus series of letters back and forth. Now, as I recall, once in February, this is like 7 months down the line, once this all happened, there is, in the letter from, let me see, I probably better look this up. In the letter of apology from Dr. Marin to defense counsel, he says, on February 15th, 1995, I received a telephone call from Mike Halkitis, the prosecutor, who informed me my absence of action on this case led to your office retaining another examiner. His call clearly shocked me into an immediate awareness that the file had been overlooked. Okay, so from that letter, which is Marin's letter to Swisher, it appears that Halkitis knew that Marin had been supposed to be working for the defense, but that his absence of action had caused him the defense to retain another psychiatrist, and Marin claims to be shocked. Later at the hearing, though, let's see what it says on that. On the other hand, the prosecutor stated at the hearing that he had inquired into Marin's availability, to testify, and that Marin said he could. Then Marin called him back to inform him that he was actually sent some materials by the defense. So we've actually got conflicting versions as to whether it was Marin who told Halkitis or whether it was Halkitis who told Marin. There are also some conflicting versions on the question of whether or not Dr. Marin was reluctant to testify in this case for the state based on his statements at trial that he felt horribly guilty about being called by both sides.
Is there any problem in this circuit about the availability of experts?
I certainly doubt it. I've seen any number of experts testify in cases. This is the Sixth Circuit out of Pasco and Pinellas. It's also in proximity to Hillsborough County, and they've used experts from there. It's also in proximity to Polk County, so I don't believe there's a problem at all.
How long a period of time was it that these records remained with the doctor's office before they were returned?
Appears to be 7 months, close to 7 months.
My familiarity with this type of an order, because I'm trying to remember back, more than 10 years ago, was that when you appointed the expert for the defendant, you did not name the expert in the order. Basically, your order was an authorization to permit defense counsel to retain an expert. And you didn't name the expert because it's supposed to be confidential. And then when the case was over, then defense counsel would submit the bill for whomever the expert was. I don't know if they do that.
That appears to be the way it was done here. I've also seen it done where the request is put in for a specific expert and then the order is granted appointing that specific expert. I think that's a matter of local practice. In any event, this is a case, I want to distinguish the Rose case, which is the case that the judge used in ruling that Dr. Marin would be able to testify for the state. First of all, the Rose case expressly distinguishes the situation we have here, which is Rule 3.216A. The Rose case involved a pathologist who was supplied with autopsy photos, I believe autopsy information and photos. And the court said that this is very different from the Pouncey situation, the Rule 3.216 situation, which specifically says that the expert shall report only to the attorney for the defendant and that the attorney-client privilege shall apply. In the situation in Rose, they said the attorney-client privilege doesn't apply because it's not covered by Rule 3.216. There was no confidential information involved. And as to the claim that defense strategy may have been discussed, they said that's not an attorney-client privilege situation. That's a work product situation. There was no work product objection made below in Rose, and in any event, they found that nothing going to work product was in fact introduced. Now, even though Rose is so intensely different than the instant case, the court in Rose did express concern with the expert switching sides, said that they doubted if this would be permitted in a civil case, and in addition said that even if error arose, that it was harmless error in that case because the testimony of the pathologist was cumulative to 4 other doctors, and one doctor in particular who was the focus of the prosecutor's closing argument in that case. Now compare that to this case. This case is Rule 3216A, where the attorney-client privilege does apply, and the expert shall report only to the attorney for the defendant.
Mr. Bulletin, you're into your rebuttal period. You can use the time, but I just want to call your attention to that.
I think, yeah, I just noticed that, and I think I best not. I think I better sit down. Thank you.
Okay. Mr. Landry?
It pleases the court. My name is Bob Landry, representing the state of Florida in this appeal. With respect to the first issue raised in the brief as to the excusal of juror Payor, I think what we need to point out is that this is a juror who made it abundantly clear to the trial court at the beginning that she could not participate in terms of the penalty phase, and under no circumstances would she return a verdict or a recommendation of death in this instance.
Counsel, haven't we seen, though, numerous times where jurors coming into one of these obviously most serious trials expresses a view initially with reference, for instance, perhaps to, well, I'll always apply the death penalty if it's a premeditated murder or a first, degree murder, or the statements like this on the other side, that after further questioning and an explanation about how the system works, and first the guilt phase and then the penalty phase, and an explanation of the factors that are supposed to be considered, that they then come back and say, well, now I understand that, and no, I wouldn't just automatically apply the death penalty, or I wouldn't automatically vote for life if that's what the law is, and now that it's been explained to me, that's what I'll do. Don't we see that virtually in every case? Would you agree to that?
Well, I would agree.
That there are jurors like that.
I would agree that there are frequently cases in which initially jurors who are not cognizant of the legal system, once matters are explained to them, subsequently can modify their answers and once they understand what the situation is.
And it works on both sides, does it not?
Correct.
Sometimes it's the state that takes and asks further questions of the witness that is committed to the death penalty and explains the system to them, and then they say, well, no, maybe I did overstate my position.
Well,
And other times it's on the other side.
That's correct.
Isn't that the purpose of allowing the lawyers to ask those questions and having that rule?
I think that's correct, and I think I'm not really criticizing the rule per se. I mean, I think it's a good rule. I think distinguishes this case, for example, from a case in Willachie, was where there was basically a single response made by the juror in Willachie to the prosecutor's question, and the judge just dismissed the juror and wouldn't allow the defense to get into it. What we have in this situation is a little bit different. We have a situation in which, after the juror has indicated her inability to perform her function as a juror, there's a colloquy going on between the prosecutor. The prosecutor says, well, Judge, I think she's made it clear. The court says, I think it's clear. And the defense attorney says, well, Judge, I think I need to ask more questions. I'd like to ask some questions. Perhaps I could suggest a line of questions to Your Honor to ask. And he suggests that, why don't you go into, give the example for example, sometimes a trial judge may be personally opposed to the death penalty, but he's sworn to uphold the law. And therefore, once a juror can get the impression that even judges sometimes have difficulty with their personal views on the death penalty, but can follow the law, maybe that would be more helpful to them.
But counsel, it's still the same issue. It's not what the response was. It's the matter that defense counsel did not have an opportunity to question the prospective juror. Wasn't that the underlying basis of Willachie and the underlying basis of O'Connor?
Well, I'm saying that what has happened in this case is in essence the trial judge provided the opportunity. In other words, by listening to the suggestion of defense counsel as to what a more appropriate approach might be, the defense did have somewhat of an input. Now, the trial judge didn't.
The judge did not go into what the defense counsel suggested, did
No, that's correct. The trial judge then reframed the questions more in terms along the lines of the Witherspoon-Witt inquiry about could you, under any circumstances, follow the death penalty.
So then how does the defense attorney have input if his suggestion is rejected by the court and he is not given the opportunity to question the prospective juror?
Well, I think then the inquiry may be whether or not the trial court abused its discretion by failing to ask the specific question that the defense attorney had suggested as a possible line of inquiry.
I thought the rule said the judge didn't have any discretion on that the judge has to allow the lawyers to ask the question.
The rule talks about that the right of the...
It doesn't say the judge has discretion to do that, and our rulings do not say the judge has any discretion about that, do they?
No, but
I thought your position is that was error, but that it was harmless because the judge asked all these other questions and because of the responses of the jury.
Well, I was trying to
clarify that for me.
I was trying to distinguish the situation that I had read in Willacy, in which Willacy was simply a situation in which there was one question asked of the juror. The juror gave the answer which the trial judge apparently found to be persuasive for removal, and there was no further inquiry.
Well, is it your position then that the judge under this rule and our holdings has the discretion as to whether or not to allow the lawyers to ask the questions or not?
I think you should not reverse a case unless there's an abuse of discretion. I think Fleckinger...
Well, so it is your position that under this rule, the court has the discretion as to whether or not to allow the lawyers to ask questions.
Well, no, I don't think the rule states that the trial court has discretion to allow it one way or the other. I think what in Fleckinger, for example, is the 4th District said that this court in O'Connell did not come out with an absolute per se rule that if the defense is denied the opportunity to conduct its own questioning, that is automatic reversible error, that each case turns on its own situation. I cited Fleckinger for the proposition that the violation of Rule 3300 is not per se automatic reversal. It shouldn't be.
Well, are you arguing harmless error, or are you arguing that the judge didn't err at all?
Well, I think he committed technical error in not following the verbatim implication of the rule that defense counsel should be allowed to ask questions.
So this is really a harmless error issue, as you see it.
Well, it's harmless error, if you want to put it in terms of abuse of discretion. It would seem to me that when you've got a situation in which there's not just one single question posed to the juror, there's repeated inquiries, the answers are becoming stronger and more unequivocal and clearer as questioning proceeds, that I think that unless the defense can show that there's something wrong or improper or incomplete in the trial judge's questioning and that he had questions that could have led to a satisfactorily rehabilitative...
Didn't you state just a moment ago that the judge didn't ask the questions that counsel...
No, I think he asked better questions. I think that the question designed by the defense would have led to more confusion, to be honest with the court. I think it would have said, well, what difference does it make whether or not trial judges, whether they're opposed to the death penalty or not, have to follow the law. I think the trial judge, I think that the questioning actually performed by the trial judge was more complete and adequate and got to the nut of the issue for the juror.
Is the state advocating, because it goes a two-way street, is the state advocating that the trial judge can restrict the type of questions that can be asked by counsel in voir dire of jurors?
Well, I think this court's opinions in O'Connor and the other cases talk about that the state may have, the court may have, certain discretion to limit the scope and how long it's going to go and that kind of thing. What I'm suggesting is that there should not be a reversal in a case like this unless the defense clearly apprised the trial court of what was inadequate about the inquiry that was being made, what he needed to pursue that would have possibly clarified or made the answers more acceptable, and he didn't do any of that. It's almost like I won't say he set up the trial court, but in a sense, when the trial court
You can't say the defense counsel set up the trial court. The one that set up the trial court was the prosecutor in this case.
Well, I don't think the prosecutor set up anybody. I think the prosecutor was basically sitting back and
But he said it does not need to be any further inquiry.
then he went on further to say, Judge, you can ask whatever you want, because the defense started coming up with its proposal as to whether the particular type of question he thought should be asked, and the prosecutor said, well, it doesn't make any difference to me, Judge, how you phrase it. I think the answers are unambiguous as it is.
What was wrong with the proposed questions by the defense?
Well, he was suggesting a hypothetical that the juror should be told that sometimes judges are opposed to the death penalty on a personal matter, but that judges are trained to follow the law and to set aside their personal views along that line. And I think that would have been a line really likely to create more confusion in the mind of the juror. I mean, the subsequent questions that were asked really got to the nut of the issue as to whether or not you could, have you made up your mind that no matter what is offered in aggravation and what is offered in mitigation, no matter what it is, you would not, under any circumstances, come forward with a death recommendation? And the juror says, that's correct, yes. I mean, I think the juror in this case was almost identical to Fleckinger.
Questions like that asked in our previous decisions? And
Well,
we said there still was the right for the lawyer to...
Well, I think, but I think in the other cases, I think...
Weren't those the identical questions?
Well, I think in the other cases, it was simply a one-question type of interrogation, and there was a magic answer given that the trial judge accepted and excused the person without allowing any kind of further interrogation. I think this was a situation that there was continuous interrogation. It wasn't just a simple... I mean, her answers, the more the questioning proceeded, the more diametrically opposed to being able to sit on the jury what this juror's answers was becoming. It's like Kimbrough, I think, this court decided a week or so ago, in which, well, that wasn't a case really where the defense was denied the opportunity, but even if this juror had come back and said, oh, now that you remind me, Mr. Defense Attorney, about judges can set aside their opinions, yeah, I might be able to do that too. If that had happened in this case, under Kimbrough and other lines of cases by this court, the court could say, wait a minute, you just told me 2 minutes ago that under no circumstances you could do it. Yeah, I mean, this juror's answers were so unequivocal and unambiguous, she wasn't going to be able to give a satisfactorily rehabilitating answer to them. If she had, the state would have exercised one of its peremptory challenges. The state didn't use any peremptory challenges in this case. They have, 10 or so under the rule. They didn't exercise any of them. Clearly, the state would not have allowed this juror to stay on. I don't think that the defense really can argue the Gray versus Mississippi line of cases that the state can't argue on a Witherspoon violation or a Witt violation that the juror would have been excused, because in those cases there was Witherspoon error. I mean, this juror was just not qualified to sit at all. And
Is this
I think it's more like Fleckinger. Yeah.
Is this error harmless because the state would have exercised a peremptory challenge, or is it harmless because your position, because the court made further inquiry?
Well, both, but I think it was harmless because of the complete inquiry made by the court. I mean, I think that I really don't understand how the juror would have turned around 180 degrees by asking having the defense pose the question. And I submit that at the very least, the defense counsel should have been required, after the second interrogation by the trial judge, to simply say, Judge, your inquiry was inadequate, and let me tell you why and how. And this is what I want to ask.
That burden is not on the defendant. The rule is quite clear that the defendant shall be given an opportunity to rehabilitate a witness. The rule is clear on that. Now, and that he was not given that opportunity. He wanted to ask certain questions. He was not allowed to ask those questions. The rule does not mention that the court then can take over and ask whatever questions it desires to ask. I don't see how you get around that there was error. Now, whether that error was harmless or not is a different matter. But I just don't see how you can argue there was no error in the face of the rule.
Well, there was probably technical non-compliance with the exact language of the rule, but the Fourth District Court of Appeal affirmed in Fleckinger, under the same situation where the defense was not permitted to ask a rehabilitating question, had asked for mistrial, and the appellate court affirmed and said, well, this rule is not absolute. Now, I think
the rule is not absolute?
In terms of an absolute rule of reversal, I mean, the language of the rule is clear that the opportunity shall be given to the counsel for both parties to interpose questions.
What instances do you contemplate that the defense counsel would not be given an opportunity to try to rehabilitate a juror? Do you think that the rule contemplates that the judge can just cut it off and say?
No, I didn't. I don't think that the rule contemplates that the defense or the state, for that matter, should be cut off. Well, I think in terms of when repetitive questions are being asked or something of that nature, then the court can step in. I don't envision a situation that it's appropriate for the trial judge in all cases simply to say, I'm not going to allow any inquiry by the defense or any particular party.
Mr. Landry, I don't want to beat this horse anymore, but you're not suggesting that the defense attorney did not preserve this issue by saying what he should have done, are you?
Well, when at the conclusion of it, when the judge says, okay, you're excused, the defense then makes a motion and says, we object, and we've been denied our opportunity, type of thing. I think to complete the record, it should have been incumbent on him to explain what inquiry was appropriate and why the trial judge's was inadequate.
And so, therefore, it is your position that this issue has not been preserved?
In terms of that, correct. And additionally, I think the record will point out...
I'm not sure I understand in terms of what.
Well, I think he should be deemed barred for the failure to articulate on the record below, after the trial judge had made its ruling.
But he asked the judge for the opportunity to examine the juror. He made a suggestion to the judge about what questions to ask. That request was rejected. And then at the time of the excusal, he said, I think the record, I just wanted to pose an objection on the record that I feel I should have had the chance to try to rehabilitate her,
Right.
and that to excuse her at this time, I think it's a violation of the constitutional laws of the United States. And then he was cut off. And is your position that this issue has not been preserved?
Well, for the reason that I think he should have been able to inform the court as to what should have been given. Additionally, I would point out that at page 159 of the record, the defense accepted the panel. He accepted the panel that was selected, and without any, as far as I can see, without any further complaint.
Well, of course, this juror was excused from the panel at that time.
Right, that's good.
Let me,
Early on.
let me, if I can, take you to another issue, and that is one of which that really that council did not fully address, but that's the matter of whether or not the status of the so-called payor in this case for this execution-type crime. It's asserted that by the defendant that he was not entitled to really tell the jury what happened to Duckett. There's no question about it in this record that the state argued that this was an execution-type killing and that basically Duckett paid $900 for it. Isn't that what they argued?
Whether or not Duckett should have been, whether the death sentence is disproportionate because Duckett didn't get anything or he wasn't charged or whatever, I don't think that came up with payor. Payor was just at the beginning
I'm
of the...
talking just about whether or not the jury should know what happened to Duckett.
I don't see that there was any prohibition on whether or not it could be argued, whether it should be argued or not. The defense didn't argue it. I don't know that there was any request, and I don't think the trial court made any ruling that you can't talk to the jury about that.
Well, what about putting in the evidence as to what charge or lack of charge was made as far as Duckett is concerned? Is the jury entitled to know that?
Well, if the defense wants to argue or present evidence that some other person got a reduced sentence, hasn't been charged, has been treated differently, he can do that. He can argue that. But the defense, as I read the record at closing argument, did not go off into a venture of disparate treatment of people.
Tell me if I'm correct from the record on this, and I want to make sure that Duckett originally was charged, and then there was a note with an offense, and then there was a no information fine.
There's some statement, I believe, it's either in the PSI, in Sanders' PSI, or in one of the other papers in the file, in which there's that comment made that Duckett or someone was originally charged but was not pursued because of lack of evidence. The trial court, in its sentencing order, by the way, noted that the defense was presenting an argument on proportionality because Duckett had been treated differently. He gave that some moderate weight, as I recall in his order, as a mitigating factor, although he said, no one's really given me any case law to support the view that it should be considered mitigation, but I give the defendant the benefit of the doubt, but there's all kinds of reasons, all kinds of valid reasons why he would not have been charged, and that's essentially what it is you've got the statement of Duckett's involvement is primarily, almost exclusively, from the confession of the defendant.
Is that right? And I have some trouble with your brief in this case, by the way. Your opponent says that you erroneously suggest in your brief that there was no testimony by other witnesses that said that it was Duckett that said that this person should be killed. Is he correct about that?
Jean Mock testified that about a week earlier she had heard a conversation in which, and she testified for the state, she was a state witness, in which Duckett made the statement that the victim, Clark, deserves to die, or he should die, something of that nature, and that Sanders responded, "I'll do it." But in terms of, that's all was said. She didn't take it seriously because she thought everyone was drunk at the time they were partying.
What was it the state's theory that this was a hired execution-style killing?
Yes.
And who did the hiring?
Duckett.
And so was the trial court correct then in saying that this shouldn't have been a factor to be considered?
No, he didn't say that. I mean,
He didn't say that? What did he say in his analysis from
he said that
contention that this should have been a mitigating factor?
he found it as a non-statutory mitigator and gave it some weight.
After saying what?
But explained that it shouldn't be given.
Didn't he in essence say that the state could treat Duckett any way it wanted to, and then speculated that, well, maybe there wasn't
Well, I wouldn't.
proof. The only proof in this record was that Duckett did the hiring. Isn't that correct?
I would not characterize the trial court's reasoning in the sentencing order that the state can do
Do you
whatever
have the
it wants.
sentencing order in front of you? Would you read that portion?
It's on page 7, paragraph numbered 7.
The defendant related in his recorded statement that he was paid $900 by Joey Duckett to kill the victim. The defense argues that Joey Duckett was never charged for the subject offense in any capacity. The defendant has not submitted authority to support this as a non-statutory mitigating factor, but resolving the question of its application in favor of the defendant, said ground has been accepted as a non-statutory mitigating factor. There exist any number of reasons why Joey Duckett has not been prosecuted for this murder, including the fact that the only proof that may exist consists of the statement of a convicted murderer, but said factor was considered and court gave it some slight weight.
And so you don't believe by that the trial court really has rejected that as a mitigating factor on the basis that there could have been any number of reasons why Duckett wasn't prosecuted?
Well, I think the trial judge is saying that he, perhaps why he's not giving it a greater amount of weight. He's giving it some weight, and he's correct in saying that there may be many reasons why Duckett wasn't prosecuted, including the degree of proof.
The only proof on this record was that Duckett did hire this fellow to do the shooting. Isn't that correct? Isn't that unrebutted on this record? So where would the trial court have to go for speculation about this any number of reasons if the only proof in this record is that Duckett did the hiring?
Well, the question, or perhaps the way it was argued below, is that Duckett wasn't prosecuted. Duckett should have been prosecuted as a first-degree murderer.
Well, if the trial court's going to evaluate that, isn't the trial court bound by the proof that's in this record and by the state's argument as to the theory of the case against the defendant?
And the trial judge found that. The trial judge found that in light of the defendant's testimony, his confession, that he was paid $900 by Mr. Duckett to commit the killing, and by the Gene Mark testimony, that there was a conversation that had occurred a week or two earlier between Mr. Duckett and Mr. Sanders. Essentially, that was pretty much the proof. Now,
I mean, this court has repeatedly held that the unequal treatment of another defendant that seems to be equally at least responsible is a major reason for reducing a death sentence on the basis of proportionality, has it not?
mm-hmm.
In a number of instances.
And
On the other hand, the trial court here has, after doing the analysis that you read, has apparently said, well, I'll still give it some slight weight. And really, that's contrary to our holdings, is it not?
Well, I don't think it is. I think, in Melendez, this court said that if just because there's another accomplice that hasn't been charged in the offense, that a proportionality argument won't stand on that basis.
This isn't just another accomplice, is it? This is the person that hired this fellow to do the deed. In many instances, the state has thought the death penalty against that person as being the most culpable of the two involved. Is that not correct?
Well, that's true. Sometimes it is a trigger man. Sometimes it is someone who's not the trigger man.
Why is not Duckett the more culpable in this instance?
Well, he may be as culpable, but there may not be any evidence to prosecute him. When
Why isn't he more culpable?
Why isn't he more culpable? He wasn't the trigger man.
I see.
This guy did it.
The state's position is that the trigger man is always the most culpable.
No, in this case.
And why again? Just because he was not the trigger man?
Well, he wasn't there. He didn't.
Well, who was Duckett? Tell us about Duckett.
Who was Duckett?
What was the relationship between Duckett and the defendant and the chief state witness?
Well,
who were they?
According to the appellant's confession,
Well, according to the state's position in the case, who were these people, including the victim?
The state relied on the defendant's confession in which he said that he was paid $900 a week or 2 weeks earlier by Mr. Duckett to do the killing, and that this situation presented itself at this time, and he killed him for that. And the $900.
What was the background, though? Were these people all involved in drugs?
Yeah, apparently this group was involved in a drug activity, and for some reason, it's not quite clear, Duckett and Clark didn't like each other, whether or not there was some drug feuding or whether or not one wanted the business of the other.
Duckett and the victim?
Duckett and the victim, or whether or not there was some indication also that the victim may have owed Duckett money. There was for some reason, Duckett didn't like the victim, Clark.
Was Duckett a leader in this drug ring?
Oh, I don't know that there's any indication as to who was a leader or who was not a leader. But I think...
What about the deposition of Nayef, or however you pronounce his name?
The main state witness.
Nashef?
Right.
Nashef, well, his testimony is that he gets a phone call when he's over at the Duckett house, and he gets a phone call to go over and meet Sanders at Sanders' apartment. So he drives over there, and when he gets to the apartment, Sanders tells him, "I'm going to be picked up in a few minutes," I guess by Clark, and you wait here a few minutes and then follow me out to the mines. And that's all he's told. And so he waits there. A truck pulls up. The victim's truck pulls up. The defendant gets in the truck. They drive off. Nashef waits a few minutes and then drives off to the mines as he is instructed. And as he's driving around there, the defendant jumps out of the bushes and flags him down and jumps into the car, and he's got blood all over him, and he's got the gun in his hand, and the defendant starts telling Nashef, "I killed him, he wouldn't die, I had to shoot him several times." He then shows Nashef a gold chain or a medallion, which he indicates that he took that, and he took, I don't know, $20 or 5 $20 bills. They then drive back to the Duckett place, where the defendant takes a shower, wipes off all the blood, and gives it to someone else, and the gun is disposed of.
Is there also some evidence that Nashef was supposed to meet the defendant on a prearranged plan after the arranged shooting took place?
Well, you have in the defendant's confession, he's giving several statements to the police. He's saying, "I called George to pick me up." He's saying Joey told George to pick me up. He's saying it just was inadvertent. I happened to come out of the bushes and I see George driving by without any pre-planning, and I jumped in the car. So the defendant's version is all over the place. Nashef's testimony is that he didn't know when he was driving out there that there was going to be a killing. I mean, all he knows is I'm supposed to pick up somebody.
Nashef gave several conflicting statements, did he not?
Nashef admitted in his testimony, both on direct and cross and every time, that he had initially lied to Detective Blum because he was scared. He was scared to death, essentially, until he came forward.
Okay, Mr. Landry, the red light is on.
I'd like to answer any other questions. If not, I'd ask the court to review the brief that we've submitted on the other issues and ask the court to affirm. Thank you.
Thank you, sir. Mr. Bulletin.
Joey Duckett was the state's whole theory of this case. Without the Joey Duckett evidence presented by the state, what you have here at best is a second-degree murder.
Wait a minute. Now, just a minute. You have the statement by the defendant himself that this was an execution. This was an execution-type slaying, And basically, he just did it earlier than when he was supposed to do it.
No, you have the statement by the defendant that this was not pursuant to the plan. This was under the influence of a crack cocaine argument where Hank flipped out and went for a cattle prod, and Mr. Sanders overreacted. Now, I'm not saying that there were conflicting versions of what happened here, but without the Joey Duckett evidence, that's all that's left.
But this defendant made more than one statement about this episode, did he not?
He made statements indicating that
Part
there
of
had
one
been a plan to kill Hank Clark, but he never made a statement that his killing of Hank Clark was anything other than a reaction to the cattle prod.
Mr.
He
Bolton,
was supposed to be the one to do it.
He was supposed to be the one to do it. He even told Detective Bloom that he would have done it probably 2 weeks later when he was supposed to do it. I mean, I'm not advocating Chris Sanders here. When you read his statement, he's not going to come off as a wonderful guy. But without the Joey Duckett evidence here, you don't have CCP, you don't have premeditation, you don't have first-degree murder, you don't have a death case.
Mr. Bolton, back on the voir dire issue, your point is under 3.300B, correct?
Correct.
That rule doesn't specifically say anything about rehabilitation, does it?
No, but it specifically says twice.
Okay, how long did this voir dire go on?
I don't recall. The entire voir dire?
Yeah.
It was not above average for a capital case, is all I can tell you.
Well, it lasted a day, more than one day?
I'd have to look at the record. I don't have it with me. It would not have been more than 2 days.
Okay. Did the court allow the lawyers to interrogate the juror?
Everybody except Ms. Payer, the one that he needed to interrogate on death qualification.
Every other prospective juror was allowed full range of questions.
Exactly the same situation as O'Connell, Hernandez, and Willisey. I want to reply. I mean, the state's argument they just made on that issue, I think, in effect, what they want to do here, they're not saying it, is they either want to overrule O'Connell, Hernandez, and Willisey, or they just don't want it applied to Chris Sanders.
What you're advocating insofar as the harmless error analysis is concerned is that a bright line reversible error rule. Isn't that correct? That there would not be any harmless error, that regardless of what the juror says, if it says it to the court and not to the lawyer, that it's automatically reversible.
If it was harmless error in this case, then it would have been harmless error in O'Connell and Willisey, because the same exact things were done. I'm advocating something close to a bright line rule when it's on the issue of death qualification, because this is going to be the kind of issue that's either always going to be harmful or always going to be harmless. And if you apply harmless error to get the state out of what they did here.
Because it's a death case, then in any other criminal case, it wouldn't be a bright line test.
That's pretty much, all right, the state argued the Fleckinger case, and that's pretty much what the Fleckinger case says. There's Green and there's Fleckinger. Green, the defense won based on O'Connell, but the dissenting judge in Green said, well, O'Connell is different. O'Connell is distinguishable because it involves the prejudice and let me see if I can find the exact language, because it's kind of important here. Okay, Judge Stone, dissenting in Green, said this is not a capital case and does not involve, as did O'Connell v. State, the prejudice that accrues to a defendant facing a death sentence who is not afforded an opportunity to rehabilitate a potential juror expressing concerns about the imposition of capital punishment. The Rhodes case, and I believe the Rhodes case and one of the other cases also talks about it being a due process issue.
So your bright line rule would not apply to cases where there was possibility of a life sentence?
It would. I'm not necessarily saying a bright line rule. I'm saying that in a situation like this, a harmless error application would swallow the rule. There's no basis for applying harmless error in this case if it wasn't applied in O'Connell and if it wasn't applied in Willisey, because the answers are just as unequivocal. I want to, referring to what Mr. Landry said in his argument, I want to quote what the trial judge below said in O'Connell. Some of these people that Terry Terrell, who's now a circuit judge up in Pensacola, I don't believe could rehabilitate under any stretch of the imagination, because I wouldn't accept a change of moral values between now and the hour he gets through. That's right. And as I pointed out before, they wouldn't impose it under any circumstance. They would not be heard to change their minds in an hour. That's just like what Mr. Landry was arguing in this case. In Willisey, the questioning of the juror, Mr. White, state attorney, is there anything that you know of that would make it impossible or difficult to serve on this jury? Not even a leading question. The juror juror, Ms. Cruz. Same as the first gentleman, if it ever came to the penalty part, I will not be able to give a death penalty sentence. Pretty unequivocal. Mr. White, you realize from all the questions that the law is, if you were to serve here, you should consider the death penalty under the applicable rules and the law that the court gives you. Are you saying you
Let
cannot
me ask
apply
you-
by that law, Ms. Cruz? Right.
Let me ask you one more question. Was this an individual voir dire, or was the whole panel sitting there?
The whole panel was sitting there.
Mr. Bulletin, the red light's on. Thank you, gentlemen. Now, the next case up will be the Jones versus Butterworth, but prior to hearing that case, the court is going to take a quick 5-minute recess.
Please rise.